Good day, class. This is a continuation with regards to our coverage for your second exam. This is actually the third video with regards to the Comprehensive Dangerous Drugs Act of 2002, Republic Act number 9165. So our video, as you all know, is part of the implementing rules and regulations set for RA 9165. This time, I'll be showing you the video for Article 3 of RA 9165. So please stand by as I post the video.
Article 3. Dangerous Drugs Test and Record Requirements. Section 36. Authorized Drug Testing. Authorized drug testing shall be done by any government forensic laboratory or by any of the drug testing laboratories accredited and monitored by the DOH to safeguard the quality of test results. The DOH shall take steps in setting the price of the drug test with DOH accredited drug testing centers to further reduce the cost of such drug test. The drug testing shall employ, among others, two testing methods: the screening test, which will determine the positive results as well as the type of the drug used, and the confirmatory test, which will confirm a positive screening test. Drug test certificates issued by accredited drug testing centers shall be valid for 1 year period from the date of issue, which may be used for other purposes. The following shall undergo drug testing. A. Applicants for driver's license. No driver's license shall be issued or renewed to any person unless he/she presents a certification that he/she has undergone a mandatory drug test and indicating thereon that he/she is free from the use of dangerous drugs, provided that the Land Transportation Office shall see to it that no driver's license is issued without a drug test certificate indicating that the applicant is drug-free, provided, further, that all drug testing expenses will be borne by these licensees. B. Applicants for firearms license and for permit to carry firearms outside of residence. All applicants for firearms license and permit to carry firearms outside of residence shall undergo a mandatory drug test to ensure that they are free from the use of dangerous drugs, provided that all persons who, by nature of their profession, carry firearms shall undergo drug testing, provided further that the Philippine National Police shall ensure that no firearms license or permit is issued without a drug test certificate indicating that the applicant is drug-free, provided, finally, that all drug testing expenses will be borne by said licensees and permittees. C. Students of tertiary and secondary schools. Students of tertiary and secondary schools shall, pursuant to the related rules and regulations as contained in the school's student handbook and with notice to the parents, undergo a random drug testing, provided that all drug testing expenses, whether in public or private schools under this section, will be borne by the government, provided, further, that the Department of Education and the Commission on Higher Education, as the case may be, shall see to it that this provision is implemented. D. Officers and employees of public and private offices. Officers and employees of public and private offices, whether domestic or overseas, shall undergo a random drug test as contained in the company's work rules and regulations, which shall be borne by the employer for purposes of reducing the risks in the workplace. Any officer or employee found positive for use of dangerous drugs shall be dealt with administratively, which shall be a ground for suspension or termination, subject to the provisions of Article 282 of the Labor Code and pertinent provisions of the Civil Service Law, provided that the Department of Labor and Employment and the Civil Service Commission, as the case may be, shall see to it that this provision is implemented. E. Officers and members of the military, police, and other law enforcement agencies. Officers and members of the military, police, and other law enforcement agencies shall undergo an annual mandatory drug test, provided that the respective heads of these agencies shall see to it that this provision is implemented. F. All persons charged before the prosecutor's office with a criminal offense having an imposable penalty of imprisonment of not less than 6 years and 1 day shall have to undergo a mandatory drug test, provided that the National Prosecution Office shall see to it that this provision is implemented by requiring the apprehending unit to have the persons charged drug tested, provided further, that all drug testing expenditures will be borne by the government, subject to the guidelines to be issued by the board. And G. All candidates for public office, whether appointed or elected, both in the national or local government, shall undergo mandatory drug test, provided that the Commission on Elections and the Civil Service Commission, as the case may be, shall see to it that this provision is implemented, provided, further, that the concerned candidates will bear all the drug testing expenditures. In addition to the above stated penalties in this section, those found to be positive for dangerous drugs use shall be subject to the provisions of Section 15 of the Act. The DOH shall be the sole drug testing licensing, accrediting body of the government to the exclusion of all other agencies. It shall be responsible for setting the standards and guidelines of operation of these facilities, as well as the monitoring of the implementations thereof. Section 37. Issuance of false or fraudulent drug test results. Any person authorized, licensed, or accredited under the Act and its implementing rules and to conduct drug examination or test who issue false or fraudulent drug test results knowingly, willfully, or through gross negligence shall suffer the penalty of imprisonment ranging from 6 years and 1 day to 12 years and a fine ranging from 100,000 pesos to 500,000 pesos. An additional penalty shall be imposed through the revocation of the license to practice his or her profession in case of a practitioner and the closure of the drug testing center. Section 38. Laboratory examination or test on apprehended, arrested offenders. Subject to Section 15 of the Act. Any person apprehended or arrested for violating the provisions of the Act shall be subjected to screening laboratory examination or test within 24 hours if the apprehending or arresting officer has reasonable ground to believe that the person apprehended or arrested on account of physical signs or symptoms or other visible or outward manifestation is under the influence of dangerous drugs. If found to be positive, the results of the screening laboratory examination or test shall be challenged within 15 days after receipt of the result through a confirmatory test conducted in any accredited analytical laboratory equipped with a gas chromatograph, mass spectrometry equipment, or some such modern and accepted method. And if confirmed, the same shall be prima facie evidence that such person has used dangerous drugs, which is without prejudice for the prosecution for other violations of the provisions of the Act, provided that a positive screening laboratory test must be confirmed for it to be valid in court of law. Section 39. Accreditation of drug testing centers and physicians. The DOH shall be tasked to license and accredit drug testing centers in each province and city in order to assure their capacity, competence, integrity, and stability to conduct the laboratory examinations and tests provided in this article, and appoint such technical and other personnel as may be necessary for the effective implementation of this provision. The DOH shall also accredit physicians who shall conduct the drug dependency examination of a drug dependent, as well as the aftercare and follow-up program for the said drug dependent. There shall be a control regulations, licensing, and accreditation division under the supervision of the DOH for this purpose. For this purpose, the DOH shall establish, operate, and maintain drug testing centers in government hospitals, which must be provided at least with basic technologically advanced equipment and materials in order to conduct the laboratory examinations and tests herein provided, and appoint such qualified and duly trained technical and other personnel as may be necessary for the effective implementation of this provision. The DOH, in coordination with the DDB, shall issue orders, memoranda, or circulars providing for the implementing guidelines and specific technical requirements related to licensing and accreditation. Section 40. Records required for transactions on dangerous drugs and precursors and essential chemicals. A. Every pharmacist dealing in dangerous drugs and/or controlled precursors and essential chemicals shall maintain and keep an original record of sales, purchases, acquisitions, and deliveries of dangerous drugs, indicating therein the following information: 1. License number and address of the pharmacist. 2. Name, address, and license of the manufacturer, importer, or wholesaler from whom the dangerous drugs have been purchased. 3. Quantity and name of the dangerous drugs purchased or acquired. 4. Date of acquisition or purchase. 5. Name, address, and community tax certificate number of the buyer. 6. Serial number of the prescription and the name of the physician, dentist, veterinarian, or practitioner issuing the same. 7. Quantity and name of the dangerous drugs sold or delivered. And 8. Date of sale or delivery. A certified true copy of such record covering a period of 6 months, duly signed by the pharmacist or the owner of the drugstore, pharmacy, or chemical establishment, shall be forwarded to the board within 15 days following the last day of June and December of each year, with a copy thereof furnished the city or municipal health officer concerned. B. A physician, dentist, veterinarian, or practitioner authorized to prescribe any dangerous drug shall issue the prescription therefor in 1 original and 2 duplicate copies. The original, after the prescription has been filled, shall be retained by the pharmacist for a period of 1 year from the date of sale or delivery of such drug. 1 copy shall be retained by the buyer or by the person to whom the drug is delivered until such drug is consumed, while the 2nd copy shall be retained by the person issuing the prescription. For purposes of the Act, all prescriptions issued by physicians, dentists, veterinarians, or practitioners shall be written on forms exclusively issued by and obtainable from the DOH. Such forms shall be made of a special kind of paper and shall be distributed in such quantities and contain such information and other data as the DOH may, by rules and regulations, require. Such forms shall only be issued by the DOH through its authorized employees to licensed physicians, dentists, veterinarians, and practitioners in such quantities as the board may authorize. In emergency cases, however, as the board may specify in the public interest, a prescription need not be accomplished on such forms. The prescribing physicians, dentists, veterinarians, or practitioner shall, within 3 days after issuing such prescription, inform the DOH of the same in writing. No prescription once served by the drugstore or pharmacy be reused, nor any prescription once issued be refilled. C. All manufacturers, wholesalers, distributors, importers, dealers, and retailers of dangerous drugs and or controlled precursors and essential chemicals shall keep a record of all inventories, sales, purchases, acquisitions, and deliveries of the same, as well as the names, addresses, and licenses of the persons from whom such items were purchased or acquired, or to whom such items were sold or delivered, the name and quantity of the same, and the date of the transactions. Such records may be subjected any time for review by the board. We hope you have enjoyed listening. More audiobooks are coming your
So I think you have seen the video quite clearly with regards to drug testing and of course for other provisions under Article 3 of RA 9165. So that is all for this discussion with this video. Um, the other videos that I'll be uploading or will be uploaded are those videos coming from the other topics for your second exam, which are basically a combination of my presentation and other resource videos. So, once again, thank you for viewing. I hope that you have learned something and I hope that you have taken notes with regards to the topics that were presented earlier. So again, thank you. And by the time you have seen this, this has already been posted in your LMS.